Once again, there has been no legal relief for Rahul Gandhi, with the Gujarat High Court listing 5 reasons why Mr. Gandhi does not deserve to have his disqualification from Parliament paused, halted, or stayed. I'm Barkha Dutt, you're with the Mojo story. In a moment from now, we'll be joined by a newsmaker on the program today, senior advocate Abhishek Singhvi, who's been arguing some of the most critical legal political cases of our time. We'll start by asking him what are the options before the Congress party as the Gujarat High Court declines to offer any relief to Rahul Gandhi, instead arguing that Mr. Gandhi had indeed impacted the dignity of a large number of people, a wide population, as the court called it. There are many other things to put to Abhishek Singhvi as well. This has been a week when Maharashtra has seen high drama, with Sharad Pawar both outfoxed and outnumbered. It's also been a week when the Prime Minister has batted for the Uniform Civil Code. The Congress seems to be hedging its bets on this, saying it is not the time for the code right now, but first show us a draft bill. So these are the three big headline stories that we'll be discussing with Abhishek Singhvi. Rahul Gandhi, the Maharashtra split in the NCP, and where the Congress should stand on the Uniform Civil Code. Let's welcome to the program our newsmaker this weekend, Abhishek Singhvi. Always a pleasure, Dr. Singhvi. Let me start by asking you whether the Gujarat High Court verdict left you disappointed and dejected.
I said disappointed, which is, of course, a synonym for dejected, but not unexpected. And I think that now it's been going on for a while. I've appeared only in the High Court prior to this, but people know enough about it. But you should need to underline those 4 or 5 gross facts which made me call the judgment completely erroneous and unsustainable. And we are therefore very confident that the Supreme Court should interfere and rectify it. The first is, in the whole attempt to paint Rahul Gandhi black and therefore justifying a non-suspension of conviction, patent errors were made. Let me give you in simple, non-legalistic way for your viewers. Number one, there is a para there, 43, 45, etc. I don't want to get into details, which says this is moral turpitude. Now, everybody knows who has studied law, or even those who have not studied law, that a defamation offense has never ever been called a moral turpitude offense. Moral turpitude is a term of art. It's a technical term which is reserved for issues like rape, abduction, or particularly morally immoral crimes. Nobody has ever used it for defamation. So, just to make sure that the learned judge is elevating it to a stage where he need not grant suspension of conviction, he uses the test, the legal test, the erroneous legal test, the inapplicable legal test of moral turpitude. Second, the basic 2 or 3 questions are not answered, Barkha, in the judgment. What are the basic 2 or 3 questions? The most important was that, assuming that the word Modi is a defined and non-amorphous class of persons, which it is not, by the way, which is the first argument, but let's assume that for a minute. Can a person who has actually been defamed by name, Barkha Dutt by name, Nirav Modi by name, Prime Minister Modi by name, Lalit Modi by name, can a person who claims to be defamed not file any defamation at all?
Well, Sushil Modi has. Sushil Modi has in Bihar.
This is not the case of Sushil Modi where a conviction has been obtained. This judgment is bad because this is not, on your own test, Barkha, what you just said. This conviction is bad because neither Nirav nor Lalit nor Prime Minister Modi filed. Can you hear me?
Yes, go ahead.
Can you hear me? Any person of that amorphous class, which by the way is pleaded to be approximately 13 crore persons. Anybody can stand up and file without showing prejudice, loss. Third, it has been proved on the record with material that a Modi, for example, a Modi from Punjab, a Modi from Gujarat, a Modi from my home state Rajasthan, or from Uttar Pradesh, has no connection to each other. There's not a defined amorphous community. I mean, non-amorphous community. No evidence is given to repel that argument. If it is not a community at all, how can any one person out of the 13 crore Modi surname people get up when the person, Mr. Prime Minister Modi, never files? Number 4, very interesting. a rarest of rare test is applied, as if it's a murder charge. We are discussing the learned judge in a particular para 4 times says serious, serious, serious. Now you are the legislature, Barkha. You don't consider it serious when you fix a punishment of 2 years. Do you fix 2-year punishment by the legislature of serious offences in murder, in manslaughter, in rape? But the learned judge repeatedly uses the phrase serious. And let me tell you on the larger picture, Barkha, there is hardly ever, to my knowledge, and most criminal lawyers across the country, ikka dukka case ko chhod dijiye, hardly ever a case of conviction in defamation with a maximum sentence of 2 years. And a case where on that conviction of 2 years, you are disqualified virtually for 8 years unless the Supreme Court intervenes. Of course, in other countries, you do not have, in true democracies, political persons A filing against political person B for what is said in a campaign. And see, ask the larger question. There are 10 BJP functionaries, including Prime Minister Modi and Mr. Amit Shah, who have used very, very strong vituperative language in political campaigns from Karnataka to north to south. That is considered okay, kosher. Today, we are facing a defamation charge of 2 years maximum, which is treated with moral turpitude and very serious. So it's an attempt really to emasculate democracy, emasculate free speech, emasculate I speak, if, to send the message out clear. You speak, you express, you freely think, and I will put you down because I want to exclude you from parliament. The real test is that, exclude you from parliament.
So hang on. Let me ask a question now. You say the High Court order is an order that emasculates democracy. In other words, you're suggesting that the Gujarat High Court judge who delivered this verdict wants Rahul Gandhi out of parliament.
No. I am saying the judgment based on the complaint by the political masters of this country is erroneous and unsustainable. The object of the complainants is to exclude Rahul Gandhi from politics, from temple of democracy. Let me ask you a simple question in answer. This great large community of 13 crore Modis is outraged according to both the complaint and the judgment accepts the complaint. But then why are all complainants, all, I repeat, Barkha, mark my words, Jharkhand, Sushil Modi, the gentleman in Gujarat, all are only BJP office bearers. There is no other Modi who is aggrieved. So you are actually orchestrating a political campaign to exclude a man from parliament. That's what I meant. I have nothing to do with the judgment, which I am anyway calling it erroneous.
The judge says that there are 10 other criminal cases against the complainant, in this case, Mr. Gandhi. He particularly cites a case by the family of Veer Savarkar. How do you respond to that?
Very, very interesting. I'm glad you asked the question. Now, these are all errors, mind you. The questions you're asking are helping to bring out patent errors, not errors where I have to argue. Take your example which you gave, Barkha, which is 2 elements, 9 other cases and one name of Savarkar. Let's take them one by one. The learned judge mentions 9 cases. Does he add, and that's the error, that in none of them is he a convict? How can a conviction for which a stay is being sought refer to 9 other cases where he's merely an accused? It's an allegation. It has not been proved against Rahul Gandhi. So you are treating him as a serial offender in 9 cases, none of which have even a semi-conviction, leave aside a conviction. 1. 2. Savarkar is very interesting. The complaint in Savarkar case, these are the problem. The devil lies in the detail and people are not bothered about details. Savarkar complaint is filed in the end of April 2023. The conviction in this case is over in March 2023. So the learned judge in appeal of stay of conviction is referring to a Savarkar event which happened 1 month after this conviction, where it's again a complaint by a BJP person, BJP sympathizer, connected person, to say, look, so suppose today I go to the Supreme Court. Between now and the Supreme Court, you file a 5th complaint. The Supreme Court will dismiss me on the basis that Barkha has filed a 5th complaint against Mr. Singhvi. Are you following my point? So is it relevant? These are irrelevant. 9 cases are irrelevant. Savarkar is irrelevant. It's a post-conviction event.
Let me ask you this. A previous time when you and I were talking, you indicated that Mr. Gandhi personally almost considered going to jail and not fighting this protracted legal battle, and he had to be persuaded to do otherwise. Has the time come to ask that as a political question again? You're going to the Supreme Court now. There's going to be no quick judgment, maybe. I don't know. You would know better. Do you think two things? One, Mr. Gandhi could apologize, cut his losses, get on with life, come back to parliament. Two, he could go to jail and make a political point.
No, first of all, let me correct you about your perception of what I said. I said Rahul Gandhi has never been scared of going to jail in a general sense. There have been other cases earlier, and he's
Okay.
been persuaded to seek bail. Otherwise, he was quite happy not to seek bail. I was not talking of this case. The
Okay.
problem with this case is different repercussions, Barkha, which I will emphasize. As going to jail is concerned, in a political activism case, Rahul Gandhi never hesitates to go to jail if he is to make a statement about the public which he is making. But here the problem is number one, they want to exclude him from the temple of democracy. Two, the exclusion they want is for 8 long years. Three, they want to exclude him particularly from campaigning in a political context and standing between now and 2024. Number four, they want to inflict a premature election on the electorate of Wayanad, which wanted Rahul Gandhi at least till 2024. So, disqualification, exclusion, and most importantly, he believes that he's right. So, he believes that for something right, why should he not fight? He has full faith in the system. He will abide by whatever the Supreme Court thinks is his fate. But the point is, to give up without a fight would be wrong. And I entirely agree with his sentiment.
What is your legal strategy going to be as you take this case to the Supreme Court? Clearly, the same argument hasn't worked at lower courts. Are you of the mind that the Supreme Court will be more open to your argument, or will you have a change in tack?
There is a saying in the Supreme Court, an error perpetuated twice or thrice requires correction even more than an error which is once. So don't go by the number of errors. Really, the only superior court which has considered it is the High Court. The other are the district court level. I do not, as I said, we found it disappointing but not unexpected. Certainly, we are very confident and hopeful that the Supreme Court, given by the number of 5 or 6 errors I have even itemized to a lay audience in your program, will find it necessary to interfere and stay. And this is for a defamation offense of 2 years. Should a person be punished with non-participation in politics when he's a principal leader of a principal party? I mean, if you are really committed to democracy, the issue will remain the larger issue that dissent, disagreement, even vituperative criticism, can it lead to this kind of defamation baji and then possible exclusion because, the process is the punishment in our system. It may take time.
Are you hopeful
So
of a Supreme
certainly
Court
we are going to
intervention?
fight in the Supreme
Are
Court.
you
We are
hopeful
hopeful.
of a Are you hopeful of a Supreme Court intervention before 2024 Lok Sabha elections? That's the key point, right?
Look, of course I'm hopeful. I'm very confident and hopeful, but I'm never presumptuous. We are respectful to the courts. We have full faith in the court system and we await it. Of course I'm
Okay.
hopeful because of the merits of the case. We have very strong merits.
Okay. Let's look at the other big political story this past week. The drama in Maharashtra. For a long time, there was a perception that Sharad Pawar may have been part of the drama. He may have been in on the game, but he genuinely seems to have been both outfoxed and outnumbered by his nephew Ajit Pawar, who has joined hands with the BJP. Now, my question to you, and this question is relevant to you not just as a leader of the Congress party, it's relevant to you as the lawyer who actually fought for the Uddhav Thackeray Shiv Sena in the Supreme Court, where the Supreme Court went along with all of your arguments but stopped short of making an intervention and instructed the Speaker to look at the issue of the disqualification of 16 MLAs, of which Eknath Shinde is one. So I have a political question for you and a legal question for you. The political question is this. Do you believe that Sharad Pawar is in on the game, or do you believe that Mr. Pawar has been betrayed by his nephew?
Barkha, uh, let me start by two opening statements. One is that since I am part of the advisory situation at the moment in the so-called Pawar case, I will be more than usual circumspect. You know that I'm very open and frank, but obviously I will not cross the boundaries of legal professional privilege. One. Two, uh, if you have seen politics, even at distant quarters, you have seen it all. So there is never an absolute answer in politics. Some of the persons who have left Mr. Sharad Pawar, the names I will not take, personal friends of mine, I am astonished. And you know whom I mean, your viewers know whom
Praful
I mean.
Patel.
I
Praful
don't think,
Patel. Of
I
course, you
don't
mean
think,
Praful Patel.
I don't mean anybody, but I know this much, that anybody who knows public life, even from a distance, would never ever have expected some of the names, some of the events, some of the statements. So the bottom line is, we have all ceased to be surprised, and we should continue to be ceasing to be surprised ever. Now, the answer to your question: there are a lot of aspects of the judgment you mentioned, the Shiva Sena judgment, which of course bind the country as a whole now, but which should be directly relevant. And that's the law, so I'm committing no breach of anything to discuss that with you. Today, I want to ask you a simple question. What is the basis of Ajit Pawar and his other colleagues from leaving and for leaving? And what is the basis of their today's claim to fame or claim to strength? Answer the question. The question is, we have got X MLAs, you have got only Y MLAs, correct? Whether it's
Yes.
34 or whatever. Now, under that judgment, which is open for everybody to read, is merely having X and Y MLAs enough for you to claim to be the NCP?
Hmm.
Is it enough for you to keep tom-tomming MLAs, which is a very small subset of a subset? The superset is the political party. The first
Hmm.
subset is the legislature party. The second subset of the subset are some MLAs of that legislature party. The Supreme Court is rightly at pains to say that what matters is the mother, the parent, the superset. Now, do you think in the common perception of people, the so-called Ajit Pawar faction has anything to show by way of being the real larger political party NCP?
You are saying that the Ajit
And
Pawar split.
one more
Yeah.
sentence. This
Yeah.
political party NCP means the political party from the top, the office bearers in the middle, the office bearers at the district, at the tehsil, not only office bearers, the membership, arm membership of the party. Now, the question is, there is nothing even claimed by Mr. Ajit Pawar in that respect. And everybody knows where those numbers lie.
Yeah. Can I ask you? You are basically saying that given the Supreme Court's sort of scathing observations about what happened with the Uddhav Thackeray Shiv Sena, the NCP split is in violation of the spirit of the Supreme Court judgment.
Letter, forget spirit. NCP's contention, stand, basis, every day tom-tomming the MLAs. The second point, Barkha. So the answer is clear. It's directly violated the letter. But second point, the MLAs themselves, which are being tom-tommed, may well be subject to disqualification. We don't know the number. Nobody's shown two-thirds numbers, provided you had a neutral speaker, a non-partisan speaker, a non-political speaker. Today, have you been shown any concrete, hard evidence about two-thirds, one-third?
So, where does that leave Sharad Pawar's legal options? Given the Supreme Court's sort of critical view of how the Shiv Sena was split, where does that leave Sharad Pawar's legal options today? Dr. Singhvi, are you able to hear me? Yeah.
Yeah. Well,
Yeah. Yeah.
we're losing some voice. I've lost some screen, but it doesn't matter. We can go on. Uh,
Yeah. Yeah.
I think ultimately this will be decided in some sense of an adjudicatory forum, whether it's the election commission or the courts, principally the former. But those who are confident that they are the ones with whom the largest numbers of the political party exist have no particular reason to do anything, to jump around. It is for those who claim to be the real political party without any numbers being shown that will may or may not have to take some legal action. But I will not go beyond those guarded comments, because certainly today the general perception, at least in Maharashtra, is that the political party is firmly with Mr. Sharad Pawar, A, and B, that the legislature MLA numbers are also not anywhere near frozen or clear as claimed by the Ajit Pawar faction.
Basically, you're
These are
saying
the
there has to
two
be a floor.
basic pillars.
Basically, you're saying in keeping with the letter and spirit of the Supreme Court judgment, there should be a floor test.
No, 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 no. Forget flow test. No, no, no. I am saying that a neutral speaker, and I'm not saying that one exists. Perhaps that species is extinct now. A neutral speaker would find out what is the NCP. The Supreme Court says so. And if you were to do that inquiry genuinely, I have no doubt, at least at the moment, that Sharad Pawar is the real NCP. But provided you do that inquiry, now the moment you do that, no protest is necessary, nothing. The political parties, the NCPs, those who have left, are subject to the whip of Mr. Sharad
Okay.
Pawar.
Okay, I have one last question for you on this subject, on the role of the speaker. As per the Supreme Court judgment, the speaker had to, in a time bound manner, take a decision on whether to disqualify 16 MLAs of the now what is known as the Eknath Shinde Shiv Sena. The Chief Minister Eknath Shinde is one of them. Do you believe, as it has been averred by the Uddhav Thackeray Shiv Sena, that Eknath Shinde could cease to be the Chief Minister of Maharashtra? And since you've already said the speaker is not neutral, why would the speaker take such a decision?
See, very clearly and pointedly, Barkha, I used the last sentence and you smiled. I said, perhaps it's an extinct species. You tell me one thing. Why does a second petition have to be filed in the Supreme Court, as has been filed, to ask you, the speaker, to decide because you have not decided after 2.5 months? Does the learned, I emphasize the word learned speaker, need 2.5 months with assistance from diverse legal brains to decide this matter finally? In 2.5 months, he has not even initiated and started the process of the Sena issue, which has been decided by the Supreme Court 2.5 months ago. So you can see where the wind is blowing. Forget the NCP. We are now talking of a done, dusted case of the Supreme Court. Clearly, the intention is to decide by not deciding. Clearly, the intention is to get a default decision because non-decisions are also decisions.
What would be the default decision in this case?
Default decisions everybody is keeping hanging because you know that if you go into the disqualification, the Shiv Sena so-called Shinde faction is clearly disqualified. There cannot be a defense. Forget NCP. Can there be a defense to the Shiv Sena walking away of those numbers of MLAs in the Eknath Shinde camp? What is the defense? There is no two-thirds claimed. So
all
therefore,
in
the
all,
Dalit speaker knows that if he takes it up, he'll have to disqualify people who are supposedly loyal to him and to whom supposedly he's supposed to be loyal. Let's be
last
blunt.
question
Let's
on
smell
this.
the
Yeah,
coffee.
yeah,
Let's
yeah.
be
Let's be
frank.
blunt. Let's be blunt. What are your options right now? What are your options right now in real terms?
See,
Let's
this
be
is the
blunt.
problem. This is the problem. The options are in a democracy, and people like us who believe in rule of law are only to keep going back to the courts. I'm now talking of the Shiv Sena case. You cannot go and hold your neck and say, look, I know I'm right, so therefore please do this. I have to go to court, and you know that process is the punishment. Time is the punishment. We all know that, and that is what the other side knows when they make the mistake. Many people do a mistake deliberately, saying that ultimately we'll be quashed, we'll be reversed, but we will gain by the time. We'll enjoy the time.
Okay, we'll wait to see how the Supreme Court intervenes in both the NCP cases and the Shiv Sena cases. I want to now end this interview with the third part of the interview, the third subject that we're looking at today, which is a very interesting constitutional subject, which is the subject of the Uniform Civil Code. Now, your party has taken a somewhat ambivalent position, saying that the Uniform Civil Code is not desirable at this stage and has asked to see a draft. I want to ask about the stage. This is a directive principle of state policy in the Constitution, which means our Constitution's architects believed it was a desirable principle. It has been 75 years and counting since India's independence. Why is this not a desirable stage for the Uniform Civil Code?
Look, this topic, I am not speaking strictly as the party because the party has made a stand clear. Secondly, I am part of a group in the party which is also going to now further take a more specific stand. So don't think that I am at all controverting the party stand or going beyond or this and that. I am explaining to you the concept, which is important for your viewers to understand.
Yes.
Let's start with what you said. So it's very clear that the framers chose their words carefully. First, they never put this clause in the part 3. They put it in part 4. And secondly, they said, shall endeavor to do something, not shall do something. Intent is crystal clear. They were, as is put in today's article by my colleague, they were not fools or ignoramuses who didn't know what they were talking about. The idea was clearly that you will make an attempt to approximate to a consensus which will then lead to this. Now, let's look at it very carefully and quickly in a few bullets. A, this government has the most divisive image, the most divisive actual acts and omissions, possibly for the last 75 years. I'm not saying it's right or wrong, but clearly the ambience of divisiveness, trust deficit, people suspecting them, minority communities suspecting them. Number two, therefore, is it anywhere near a consensus? Answer is clearly no. That endeavor is missing. Number three, is there any specificity in what you say? You are, Barkha, in power for 9 years in the center. You are also in power for about 10 states on and off. Have you passed legislation? Obviously, no. You are now flailing your arms all over in one state, Uttarakhand, in another
Yeah.
state here and there, because 6 months before the elections. By the way, you've been in return to power in Uttarakhand earlier, so therefore you had a time. Number four, in these 9 years, forget not building a consensus, forget making the country more divided, making consensus impossible. Have you produced a draft? I'll tell you why a draft is important. I am not at all against the UCC. I would think it's the best idealistic thing, like mother's milk or blue sky or no environment pollution to get. But the point is, the reason why you are not giving a draft is the following: because God and devil lie in the details, Barkha. You don't want the details. You want to flail it like a, you know, a dead body of an animal, like for cheap political gains. Take three examples. First of all, this is not about marriage and divorce. This is about succession. This is about adoption. It's about alimony and maintenance. Now, for each of this, will you approach 7 states in the Northeast and amend 5 articles of the Constitution? I won't bore you with details. 371, 371F, this, that.
Well,
All of which gives you
per the
all of
Nagaland chief minister, the Northeast could be exempt from the UCC. We don't know. These are media
no.
reports.
The point is, you don't know because you have nothing to show for anything. You're just knowing it in the political speeches. Why don't you know? Because the central government is irresponsible in giving you no blueprint. As a matter of fact, considering that Manipur is in flames with inactivity of this government, do you want to have another flame set up in another state in Northeast? Next, what will you do with? I'm giving you simple examples. That's why the devil and God lie in the details. In the South, you can marry your first cousin. In other parts of India, you can do it also. I am not at all saying right or wrong. Are you ready? I'm now talking of the majority community, by the way. I'm not talking of the minority community where also some of this applies. Are you ready to address it? Have you made an attempt to address it? Number four, what will you do with the other usual, bugbears, Hindu undivided family? Even today, people tend to forget. Forget the minorities, forget the tribals. The customary law of the majority Hindu community prevails over the statutory law. Today, technically, if you and I are part of some sub-community in Uttar Pradesh where the customary law allows different practices, we'll be governed by that.
For example,
no, in the Hindu code, there are exemptions saying that this Hindu code, which Nehru fought for reform and did, will not override customary law. One example is Hindus in Tamil Nadu. In Tamil Nadu and other states in the south, it is not uncommon to find marriages between I forget the exact, the bhuas or the mamas side one and the other side related. That's Hindus. I am not at all observing on the value judgment. I am saying you are making a fool of the people. Now then comes the real messy issue of personal law of minorities. And this is not personal law about only marriage. It's about alimony. It's about succession. Will you touch that? I actually would say, as the law commission of your government has said, your government's law commission, Mr. Modi's government law commission has said so, much better is to look at reform, not uniform. Yeah. Reform means discriminatory provisions. Discriminatory
Maybe.
provisions. For example, I don't think that you can put triple talaq banning and what they are now trying in the same basket. There are
Let
problems
me
with the triple talaq in terms of procedural things, but I would not oppose it in the sense that it is completely, not untouchable.
let me put it to you like this. Let me put it to you like this. You're also a passionate champion of the same-sex marriage cause. You have argued in support of that. And one of the formulations you gave was, rather than getting into the business of personal laws, let's just say those who want same-sex can get married under the Special Marriage Act, which can be amended. I put it to you that the Uniform Civil Code's idea is not homogeneity. It is that everybody can continue their customs, their rituals, except when they contradict the fundamental rights as guaranteed by the Constitution. What would be the problem with this idea? What would be the problem with this idea?
A very good question. Shows that you're becoming a cleverer and cleverer lawyer doing these programs with me. I'll tell you why. I'll tell you why it's a clever question. But there is a fundamental difference. In same sex, Barkha, we were arguing for a elective marriage under a platform known as Special Marriage Act, SMA. So we said that if A and B choose to marry under SMA, then other things can be suspended because both are electing to marry. I want to ask you that what you said is absolutely right. I wish it was possible. How do you have anything resembling a uniform or a homogeneous code where every personal law of every community is left to the optional voluntary situation? Then you have no UCC anyway. Then you are where you are today. The analogy between same sex and here will not apply fully or even partly because you are. How do you decide? Either you say the UCC will apply only. I'll give you one way you can do it, but is it enough? Is it satisfactory to say
I think it
the
should apply
UCC will apply
only
only
when a
to marriage?
fundamental. No, I think it
No,
should apply
it shall
only
not apply.
when a fundamental right is contravened.
How do you
Shouldn't it apply
define?
then?
No. How do you define fundamental right? The Muslim thinks his succession law is fundamental right. The Hindu in South India thinks that his right to marry his cousin is his fundamental right. I, as a tribal in the Northeast, think that those 6 tribal customs are also fundamental right. These are vague words. These are ways to avoid the issue. You will see, either you don't tread down that path, but if you go down the path of UCC, you have to address it directly. Then the only way is this UCC will govern uniformity or homogeneity in ABC. You have to state the ABC, and in XYZ it shall not apply. If you want a UCC like that, you can try it. Give us a draft, we'll react. But then possibly you will be in that draft leaving out 75, if not 90% of the XYZs for your 10% tokenism.
So are we saying a country as diverse as India can never have a uniform civil code?
No. I believe a country as diverse as India first needs a very converging government. Certainly not Mr. Modi's polarizing ethic. It might sound like a very vague statement by me, but it's very, very important
I
when
mean,
you are.
it's a political statement. It's not a legal statement.
No,
Right?
it's because
It's a subjective,
these are not
interpretative
legal
political
issues.
statement.
These are issues of law of a social acceptability. These are issues of law based on the bedrock of social acceptability. They are not pure legal issues at all. Now, you have had governments, including of the BJP, which might have managed it. Just consider Mr. Atal Bihari Vajpayee's healing touch approach. What it could have done in this situation. That's the reality. Number 2,
what is
once
the
you
Goa
get to that.
example? What does the Goa example teach us?
Now, this is another bit of a very funny thing happening. Not only Goa, let's say what is this? Uttarakhand also. Why is it funny? It's funny because it's a supreme irony. In the name of uniform civil code, underline the word uniform. In the word of homogeneity, you are actually having asymmetric, dissonant, non-homogeneous, statewide patchy creations. So you, Barkha Dutt, can do something when you are in Uttarakhand. Citizenship is of India. When you travel outside Uttarakhand and relocate for work in Delhi, your children may have to follow a different law. And when that eldest child of yours relocates for work in Nagaland, he or she may follow a third law. I mean, this is nothing but a statement for cheap political gain to show, look, 9 years we did nothing, elections are next year. We are showing you that we are doing something in Goa and Uttarakhand. The whole idea of a uniform civil code is not to have patchy, asymmetric, non-homogeneous ideas in 2 or 3 different states.
So let's end with a last question on this. You said, in principle, you think the Uniform Civil Code is a good idea. You are making one political point and one legal point to oppose it. The political point is you do not believe that this government, which is associated, you believe, with polarizing politics, is the one to implement it. And the legal point you're making is perhaps you have to restrict the subjects on which the Uniform Civil Code applies. Am I summarizing you correctly?
And a third point, that first of all, don't say the first point in the abstract, because that is what will be quoted. Basically, Singhvi in support of UCC. That becomes an incomplete statement. The third point, the devil and God lies in the detail. You must have a very detailed draft to know what to include and what to exclude, on which we can react. Today, otherwise, it's a political gimmick.
But the draft could be placed before Parliament in the next session.
Well, I mean, as and when it comes, of course it can be placed. I mean, we have seen nothing. We have seen talk. We have seen no draft.
What would be the best way forward, before we close, on the Uniform Civil Code debate? What is the best way forward?
I would believe that you need to rewind. There is no question of people agreeing or having a consensus on Uniform Civil Code with the kind of atmosphere we have here. If I speak in favor of this consensus, I will be called a Muslim supporter. You will be called a Muslim baiter. These kind of phrases are now rife in this country. Now, why is this happening? And in the middle of all this, you're talking of uniform. So the first step would be that you have to provide a very different healing touch. Second step is come with a draft specific code where you tell us ABC are exclusions, XYZ are inclusions. And then you will have people saying, okay, let's keep AB out of ABC and let's not keep XY out of XYZ. Then we can go forward at least.
Okay, let's wait for the draft and we'll have you back then. Thank you very much, Abhishek Singhvi. You do manage a way to be associated with all the headline stories, and you keep us busy and yourself busy. So we look forward to talking to you again. Thank you so much, Dr. Singhvi. Thank you, sir. Take care. It's great to see you here. Thank you for watching our work. If you haven't subscribed yet, don't forget to click the bell icon and subscribe to Mojo Story and support independent, robust journalism.